Now, Carl, medical negligence, medical malpractice, they're
same thing.
It's the same thing?
It's actually, there's a standard of care that is established throughout the United States for the care and treatment of patients. And in a medical negligence or medical malpractice is simply a deviation from that standard of care. But in order to establish that, you have to, well, before you can even file a lawsuit, you have to have the medical records reviewed by a physician, and then that physician has to be willing to sign an affidavit that the offending physician fell below the acceptable standard of care. That is the basis for the cause of action.
And a lot of cases that our office looks at are immediately excluded, not because there was no negligence, but simply because the injury was not bad enough, fortunately for them, to warrant the money that it would take, to outlay it would take to bring one.
Right, but to put that in plain English so that the audience understands it, you might have an injury done because of a medical malpractice that you cannot afford to prosecute, because in order to prosecute a medical malpractice case, it takes a lot of money. It's a very expensive, drawn-out process. The same injury caused by an automobile wreck might be a perfectly good case for somebody to handle, but not in the context of a medical malpractice case.
And we'll talk.
The legal information supplied in this broadcast is general information only and is not intended to be legal advice for any given situation. Do not rely on broadcast information without consulting an attorney. Contingent attorney's fees refers only to those fees charged by the attorneys for legal services. Such fees are not permitted in all types of cases. Court costs and other additional expenses of legal action usually must be paid by the client.